Hey guys, my name's Luca, and I'm going to be covering automobile law. So, what is an automobile? Defined by federal law, an automobile is a self-propelled vehicle that is operated on the highways and streets and is propelled by the use of motor vehicle fuel. Pursuant to 15 USCS Section 1231C, the term automobile includes any passenger car or station wagon. What is automobile law? Automobile law are laws and regulations that govern the operation, use, and ownership of automobiles. It includes many different legal issues such as vehicle regulations, insurance requirements, liabilities and accidents, and traffic laws. So a quick synopsis of automobile law. In 1901, the state of Connecticut created the first statewide traffic laws. These laws regulated vehicle speed, creating the street limit to 12 miles an hour and 50 miles an hour on country roads. In 1910, New York developed the first DUI laws, and these included a $1,000 fine and possible jail time. In 1930, three-way traffic lights were introduced nationwide, including the same green means go, yellow means slow, and red means stop, which is still used today. In 1950, the seatbelt was created, and 1 year later, in 1951, airbags were created. In 1966, the Department of Transportation was formed, and this was a huge step in automobile law in the US. So how is automobile law dealt with? There are numerous different ways automobile law is enforced, but on a federal level, there are different departments and agencies that regulate all aspects of automobile law. And some of these are the Department of Transportation, the National Highway Traffic Safety Administration, and the Federal Trade Commission. These agencies and departments manage the safety of automobiles and also regulates purchasing and marketing practices of manufacturers and dealerships. At a state level, each state has its own different set of laws that govern different aspects of automobile law, such as liabilities, insurances, and traffic violations. These laws can vary from state to state. Automobile defects. When a car brand sells their vehicles, they are required to have the obligation of keeping people who purchase their cars safe, which is what the NHTSA is for. There are thousands of car accidents every year that are blamed not only on the driver, but on the car itself, and the manufacturers could be liable due to warning or label defects and manufacturing defects. When you believe an accident was caused by a defect of your automobile, some of the possible liabilities you want to aim for are strict liability, negligence, or breach of warranty. You also want to make sure you have testimony, proof of vehicle defect, proof of damage, police reports, vehicle warranties, medical records, and also witness statements to help your case against the car manufacturer in court. So let's imagine you're in a car and you get rear-ended and all of a sudden it bursts out into flames. What do you do? This case is a great example of that. Grimshaw versus Ford Motor Company, the case of 1981. These are the facts. Lily Gray and her backseat passenger, Richard Grimshaw, a 13-year-old boy, were rear-ended in their Ford Pinto on a freeway, followed by their car suddenly erupting into flames. Gray suffered fatal burns, as for Grimshaw, he suffered severe and disfiguring burns on his entire body, including his face. Both Gray and Grimshaw sued Ford Motor Company and others, followed by a 6-month jury trial. The plaintiffs in this case alleged that the Pinto had a design defect that made the vehicle prone to bursting into flames after being rear-ended, being that the rear axle punctured the fuel tank. The plaintiffs argued that Ford Motor Company knew about this, yet they still sold their vehicles to the public. Ford made many appeals denying judgment that there was defects with the car, and that there was a multitude of errors such as misconduct of counsel, and the punitive damages award was unauthorized and unconstitutionally invalid. The case went to trial, and Grimshaw was awarded $2.5 million in compensatory damages and $125 million in punitive damages, and Gray was awarded $560,000 in punitive damages. So these are the issues of the case. The plaintiffs argued that Ford Motor Company failed to warn their customers that the Pinto had a dangerous design, and that Ford should have included a warning label on the car. The plaintiffs contested also that Ford were aware of this defect, but decided not to make any changes to the car to ensure safety of their customers, being that Ford's conduct came to gross negligence. The plaintiffs argued that the Ford Pinto had a design defect that made the car prone to bursting into flames when rear-ended, and that Ford did not attempt to fix this hazard even though they were aware of it. This defect was due to the fuel tank being placed directly behind the rear axle of the car. So the rules and verdict of this case. The court gave many rules, being that the manufacturers have the obligation of reasonable care when designing their products for customers and should provide warnings if they are dangerous. The punitive damages award should be relevant to the defendant's conduct and how much harm the plaintiff suffered. Punitive damages may be granted where the manufacturer's conduct is willful, and that the financial resources of the defendant should be accounted for also. These rules gave the plaintiffs a sense of equity as the court recognized that Ford Motor Company was at fault and chose profit over safety of their customers. So the final verdict of this was that Gray received $560,000 in punitive damages and Grimshaw received $2.5 million in compensatory damages. After Ford's many appeals, the $125 million of punitive damages awarded to Grimshaw was remitted due to condition of denial of the motion, and only $3.5 million in punitive damages was awarded instead. Thank you for listening, and any questions?